Good morning. This is Rajeshkumar. Today we are going to analyze one problem question on tort law, pure economic loss. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer fully. Problem question: Mary, who is terminally ill, consults her regular solicitor David, one of the partner at Temple and Co., a high street law firm, about making a change to her will. Her original will included a bequest of £100 to her gardener Young. Mary wishes now to increase to £10,000 and tells Young that she will doing so in recognition of his excellent service. In anticipation of this, Ian promises his daughter Sarah that when he receives, he will give her a gift of £8,000 to assist her in the purchase of a flat. David allocates Mary's case to Amina, a trainee solicitor who has just started working at Temple. Amina drafts a new will for Mary, incorporating Ion's increased bequest. However, A fails to have the new will properly witnessed, making it invalid. Before this has been discovered, Mary dies. When Ian discovers what has happened, he becomes depressed and make a serious suicide attempt. Sarah is now not able to buy a flat. We have to advise Ian and Sarah. This scenario involves claims of pure economic loss stemming from negligent misstatement and professional negligence by Amina, a trainee solicitor at Temple and Co. The legal issues include the duty of care under the Headley-Bryan principle, standard of care for professional negligence, vicarious liability, and the remoteness of damage in Ian's and Sarah's respective claims. Negligent misstatement and pure economic loss. Headley-Bryan established that duty of care arises for the pure economic loss where a special relationship exists. Defendant assume the responsibility for claimant's reliance. The claimant reasonably relies on the defendant's advice or services. Here, a Temple and Co. through Amina undertook the responsibility for drafting Mary's will. Jan, as a beneficiary, indirectly relied on his service to receive his increased bequest of £10,000. As per Whiteton versus Jones in 1995, the duty of care to third-party beneficiaries, the court held that solicitor owe a duty of care to intended beneficiaries of the will. Even though Ian was not a Temple's direct client, he is an intended beneficiary, and any negligence in drafting the will forcibly affect his interest. So Amina's failure to ensure the proper witnessing of the will caused Ian's pure economic loss. The duty of care was owed to Ian as the intended recipient of the increased bequest. Professional negligence and breach of duty and standard of care. Breach of duty and the Bolam standard. The Bolam standard from Bolam versus the Freon Hospital Management Committee case in 1957 assess whether a professional has made the standard of care expected within their field. In Wilshire versus Essex AHA case in 1988, the court distinguished between the standard expected from an experienced professional and that of a trainee. However, Amina, even as a trainee, must meet the standard of a reasonably competent solicitor handling the will, drafting under the supervision. So, the Amina's failure to ensure the proper witnessing of Mary's will constitute a clear breach of the professional standard of care. Temple and co supervision procedures may also be scrutinized. In other words, a duty of care arises when a solicitor undertaking the professional responsibilities. In Boyce versus Jones case extends the duty to intend the beneficiaries of a will, even though there is no direct contractual relationship between the solicitor and the beneficiary. The David, through Temple and Co., owed Ian a duty to ensure the will was properly executed. This duty extended to protecting Ian's intended economic interests. Amina, a trainee solicitor, failed to ensure the will was properly witnessed, breaching the professional standard of care. The standard is determined by volume test, which requires the professional to meet the standards of a reasonably competent professional. In Wilshire versus the ESX case in AHA, the standard of care is objective even for a trainee. So the Amina's failure constitutes a breach of his standard. The failure to properly witness the will directly caused Ian's loss of the increased bequest. Under wagon mount number one case, the only foreseeable damages are recoverable. So the Ian's depression and suicide attempt raises question of remoteness. However, the psychological harm stemming from financial loss may be too remote unless reasonably foreseeable. Hence, the White was a chief constable of South Yorkshire. The psychiatric harm required the specific proximity and the foreseeability. What about the Sarah's claim against the Temple and Co? The pure economic loss and negligent misstatement. Sarah's claim is derivative as her financial loss depends on Ian's promised bequest. For her to succeed, she must establish a duty of care under the Headley Brand versus Hiller, like a special relationship, reliance, and forcibility. And Sarah was not in the direct communication with Temple and Co. Her reliance on Ian's promise might not establish a direct relationship between Temple and Co. and herself. Consequently, the firm's duty to her is unlikely to be established under the Headley Brand principle. The remoteness and forcibility, the Sarah's inability to purchase a flat constitute the pure economical loss. Wagon mount restricts the recovery to forcible damage, but her reliance on a third party, that is the yarn, weakens the causal link. Vicarious liability of Temple and Co. For the Temple and Co. to be vicariously liable for Amina's negligence, the following test must be satisfied. That is the employer-employee relationship. Amina is a Chinese solicitor, clearly an employee of Temple and Co. Course of employment, the negligent act, failure to ensure proper witnessing of the will occurred while Amina was performing her professional duties. The close connection, the negligence in drafting the will is sufficiently connected to Amina's role as a solicitor. So the Temple and Co. is vicariously liable to for the Amina's negligence. Causation and the remoteness of the damage, the loss of £10,000 bequest is a direct consequence of Amina's negligence. But for Amina's failure to ensure the proper witnessing, Jan would have received his increased bequest. What are the remoteness of the damage? Wagon Mount, number one, 1961. The general test for the remoteness is whether the type of harm was reasonably foreseeable. Beyond economic loss, the loss of £10,000 is a foreseeable consequence of the negligent drafting of the bill. Eon's suicide attempt in Page versus Smith in 1996, the court distinguished between the primary and secondary victims. While Eon's depression following the financial loss might be foreseeable, a suicide attempt likely falls outside the scope of reasonably foreseeable consequences. In the key case versus the White versus Chief Constable of South Yorkshire in 1999, restricted claims for the psychiatric injury, emphasizing that damages must be proportionate to the defendant's breach. The Soros' inability to buy a flat stems for an Ian's promise, which was the contingent on receiving the bequest. However, Sarah is a third-party claimant, and her financial loss was not directly forcible by Temple and Co. In the case of Goodwill versus Pregnancy Advisory Service, highlights that a duty of care does not automatically extend to all the third parties. So there's a Eon's direct financial loss is recoverable, but his suicide attempt likely fails the remoteness test. The Sahara's financial loss is too remote and unlikely to be recoverable. Contributory negligence, Temple and Co. may argue the contributory negligence if Ian failed to mitigate his losses after discovering the biggest issue. However, this defense would likely be weak given Aeon's reliance on the temple's professional services. The exclusion clauses, if Temple and Co. had attempted to limit the liability via disclaimer, this could affect the recovery. However, the professional negligence disclaimers are subject to reasonableness under the Unfair Contract Terms Act 1977, which may render them unenforceable in this context. In other words, Temple and Co. may argue that Ian should have verified the will execution. However, this is unlikely to succeed as Ian reasonably relied on the professional expertise. Ian, severe depression and suicide attempt may be deemed unforeseeable and it's limiting the recovery. So, Ian, case the Temple and Co. is liable for the professional negligence, resulting in Ian's financial loss. However, his psychiatric harm may be deemed too remote for the recovery. In other words, Ian has a strong claim for the pure economic loss under the White versus Jones. He can recover £10,000 intended bequest. However, the damage for his suicide attempt are unlikely due to remoteness. About the Sarah case, the Sarah's her claim for the pure economic loss under the Headley Brine is weak due to the lack of direct relationship with the Temple and Co. So the recovery is unlikely. In other words, the Sarah's claim of £8,000 is weak. She is not an intended beneficiary of the Mary's will, and her loss is too remote to establish a duty of care. About the Temple and Co. Is vicariously liable for Amina's negligence. They should consider reviewing their supervision policies to prevent future breaches of the professional duty. In summary, while Ian's financial loss claim succeeds, both Sarah and Ian's claim for psychiatric harm face significant legal hurdles. Thank you.